Hello everyone. Welcome to the Blockchain News Club. I am so excited to bring the latest update in the XRP lawsuit. With the latest turn on events, the lawsuit is expected to be settled before January 22, which means a $1,000 XRP overnight. The crypto community is still awaiting the ruling in the Ripple and Securities Exchange Commission (SEC) case after initial rumors indicated the matter might be settled back on December 15. It is worth noting that the United States regulator sued the blockchain company for illegally selling over $1.3 billion worth of XRP tokens. According to the SEC, the tokens were securities during the sale between 2013 and December 2020. The SEC claimed that XRP is a security. In general, a security is a traded financial instrument representing ownership in a corporation or similar entity but has no utility. For instance, shares are commonly defined as securities by publicly listed firms in order to obtain finance. Since XRP tokens were used to fund Ripple's platform, which facilitates money transfers for retailers, a civil action was filed at the end of December 2020. The sales of XRP also enriched the platform's management. However, it is essential to note that as per the SEC, Bitcoin, BTC, is not a security. The legal definition of securities can be read here. The United States SEC versus Howey test was a landmark Supreme Court case in 1946, which aids in determining whether a transaction falls within the Securities Act of 1933's definition of an investment contract. According to the Howey test, the investor's control over the profit is a critical factor in determining whether or not an investment contract is a security. It is usually considered a security if the investors have no influence over the asset. So, did XRP comply with the requirements of the Howey test? According to the SEC requirements, securities must be registered with the SEC and some financial information must be publicly reported. The purpose is to protect investors' interests while combating fraud. The SEC determined that XRP satisfied the Howey test requirements. Instead of going to trial, the SEC settles most of its lawsuits. Individual crypto companies submit to the SEC's demands and pay penalties in order to be released. Unlike many others, Ripple went all the way and engaged in a legal brawl. Ripple lawyers claimed that the SEC never warned nor gave any notice to the organization. The U.S. regulator also accepted that Ripple wasn't notified that XRP could be classified as a security. As a result, Ripple believed the SEC was biased in applying the security concept to virtual currencies like XRP. If this is found to be true, the Commission's authority will be weakened, not to mention the credibility of its argument. Ripple has specifically mentioned some of the links SEC members have had with other crypto platforms, namely Ethereum. While there is currently no proof of these linkages, the Commission gave Ethereum a pass on securities legislation, saying that it is operating in a decentralized manner all while using XRP, which seems suspicious. The series of events during the Ripple vs. SEC lawsuit. December 21, 2020, the SEC filed a lawsuit against two executives of Ripple Labs and the company itself. Instead of meeting the SEC's demands, Garlinghouse declared to defend themselves in the XRP court case. December 28, 2020, Coinbase announced delisting the XRP token from the exchange. March 3, 2021, Larson and Garlinghouse sent letters to the U.S. District Court Southern District of New York magistrate arguing that the SEC lacked fair notice. March 8, 2021, the SEC responded by requesting the judge for a hearing immediately. March 22, 2021, the SEC was told that the XRP token has a currency value and utility, distinguishing it from BTC and ETH by Judge Netburn. April 13, 2021, the Token Safe Harbor Proposal 2.0 was published by Hester M. Peirce, SEC Commissioner, to offer a 3-year grace period for developers to understand their participation in the decentralized networks concerning exemption from the securities law. June 14, 2021. The court extended the SEC's deadline for disclosing its internal crypto trading policies to August 31, 2021. August 31, 2021, the SEC must disclose its internal crypto trading policies on this day. October 15, 2021, expert discovery deadline for gathering opinions from experts in the fields of cryptography and securities. January 24, 2022. Netburn has granted the SEC until February 17 to appeal her earlier decision that the defendant Ripple Labs provide over some sensitive government documents in the SEC's case alleging that the XRP coin is unregistered security. December 15, 2022, both Ripple and the SEC have made their final submissions and amici briefs on the matter. At the moment, both parties have filed their final submissions, hinting that the conclusion date might be near. Ahead of the final ruling, defense lawyer James Filan revealed that the SEC had made another submission seeking to seal some documents. In particular, the regulator wants to seal documents in 3 categories, including names and identifying information of the SEC's experts and XRP investor declarants, personal and financial information, and internal SEC documents reflecting debate and deliberation by SEC officials. Notably, Ripple recorded another win after the court denied the SEC's request to remove the consulting firm's names that helped assemble expert witnesses. However, following SEC's request to seal the documents, the agency has come under sharp criticism facing allegations of corruption. Previously, Ripple CEO Brad Garlinghouse had accused SEC of failing to go after entities like FTX, whose founder Sam Bankman-Fried is facing allegations of fraud in the trading platform's collapse. Interestingly, in the course of the hearing, Ripple registered minor wins after the presiding judge overruled SEC's attempt to withhold the documents relating to former division director William Hinman. According to the documents, in 2018, Hinman had referred to Bitcoin, BTC, and Ethereum, ETH, as not securities. Indeed, the SEC has maintained that the documents are confidential and entail internal deliberations. At the same time, both XRP and Ripple filed a joint motion seeking an extension until January 13, 2023. The 2 entities filed the Daubert motions raised before or during the trial, aiming to exclude the presentation of unqualified evidence, and accompanying exhibits on the public docket with redactions consistent with the court's sealing ruling. As reported by Finbold, pro-XRP lawyer John Deaton projected that the final ruling could be made either April or May next year. Additionally, lawyer Rodrigo Serra had filed a request to appear as pro hoc vice, an attorney counsel from another jurisdiction, on behalf of the crypto-focused investment firm Paradigm Operations LP. Elsewhere, Nicole Tots, an attorney representing the co-defendants in the lawsuit, submitted a motion to withdraw. In the submissions, the lawyer pointed out that other attorneys at the law firm Cleary Gottlieb Steen and Hamilton LLP would continue to be the counsel of record for Ripple CEO Bradley Garlinghouse on the case. All the facts lead us to believe that the XRP lawsuit settlement is around the corner and the XRP token will be classified as a commodity, not a security. Once the settlement news becomes public, the price of XRP will soar beyond our wildest expectations. Buckle up your seatbelt and get ready for the ride of our lives. Thank you for watching. Please subscribe for regular updates in the blockchain community.